My boss fired me one day before my bonus vested. He thought he saved $10 million. 3 months later, his entire firm collapsed because of one sentence he ignored. My name is Lauren Blackwell. I'm 40 years old, married to my husband James, and we have 3 kids. Sophie is 14, twins Max and Emma are 11. For nearly 10 years, I worked as Senior Vice President of Portfolio Management at Titanium Equity Partners, a private equity firm in Manhattan. Private equity is intense. You're managing hundreds of millions in investments, dealing with aggressive timelines, working 80-hour weeks regularly. It's not for everyone, but I was good at it. Really good. I joined Titanium right after business school, started as an associate, made VP in 4 years, senior VP by year 7. I managed a portfolio worth over $300 million. My investment track record was exceptional, average returns of 28% annually over 9 years. In private equity, that kind of performance is rare. I was one of the firm's top performers. My compensation reflected that. Base salary of $400,000, annual bonuses typically around $500,000. But the real money was in the long-term incentive plan. When I made senior VP, Titanium offered me a special compensation package, a $2 million retention bonus and stock options worth approximately $8 million. The catch? They vested after 10 years of employment. 10 years. If I left before that, I got nothing. If I stayed, I got $10 million. That's how private equity firms keep their top talent. Golden handcuffs. My 10-year anniversary was December 15th. I'd marked it on my calendar. James and I had plans. That vesting money would pay off our mortgage, fund the kids' college accounts, let me finally reduce my hours and actually see my family. 6 months before that date, things started getting strange. Victor Ashford, the managing partner, began criticizing my work in ways he never had before. In meetings, he'd question my investment decisions. He'd request unnecessary additional analysis. He'd make comments about fresh perspectives and new energy. My colleague Michelle noticed it too. "Lauren, what's going on with Victor? He's been targeting you in every meeting." "I don't know. My performance numbers are solid. Better than solid." "Your 10-year anniversary is coming up, right? When does your compensation vest?" "December 15th. Why?" She looked uncomfortable. "Lauren, you know Victor. He hates paying out those retention packages. I've seen him find reasons to push people out right before their vesting dates." "That's illegal." "It's hard to prove. He makes it look like performance issues or restructuring. Be careful." I should have listened more carefully to that warning. 2 months before my anniversary, Victor called me into his office. "Lauren, we need to discuss your portfolio performance." "My returns are up 32% this year. That's the highest in the firm." "Yes, but I'm concerned about your risk management approach. You're taking positions that could expose us to significant downside." "Every investment has risk, Victor. That's the nature of private equity. My risk-adjusted returns are excellent." "I'm not convinced. I want you to restructure 3 of your major positions. Reduce exposure." "That would lock in losses on positions that are about to mature profitably. It makes no financial sense." "It's not your decision, Lauren. Do it." I restructured the positions as ordered. 2 weeks later, those investments paid off exactly as I'd predicted. Titanium made $12 million in profit. Victor said nothing about being wrong. 1 month before my anniversary, the criticism intensified. Victor started CCing the other partners on emails questioning my decisions. He requested weekly portfolio reviews, something he'd never done before. He was building a paper trail. I called Michelle after one particularly aggressive meeting. "He's going to fire me before December 15th. "Can you prove that's why?" "How? He'll claim it's performance-based. I need to talk to a lawyer." I contacted Daniel Green, an employment attorney who specialized in executive compensation disputes. I explained the situation. "Lauren, do you have your employment contract?" "Yes." "Bring it. Let's review every word." We spent 3 hours going through my contract. Daniel asked detailed questions about the vesting schedule, termination clauses, everything. Then he found something interesting. Lauren, look at Section 12, Paragraph 4. It says compensation vests on your 10-year employment anniversary. What exact date were you hired? December 15th, 10 years ago. What time? I don't remember. Morning sometime. Why? Because if you were hired during business hours on December 15th, technically your 10-year anniversary occurs during business hours on December 15th. The contract doesn't specify end of day, it just says the anniversary date. I'm not following. If Victor fires you on December 15th, but your anniversary technically occurred at the moment you were hired 10 years earlier, say 9 a.m., then you've already hit your anniversary before the termination takes effect. Your compensation would vest. That seems like a technicality. Employment law is all technicalities. Do you know what time you were hired? Is there documentation? HR would have records. My offer letter might specify. Get that documentation. If we can prove your hire time, we might have a case even if he fires you on the anniversary date. I went home and tore through my files. I found my offer letter. Start date, December 15th, 9 a.m. I sent it to Daniel immediately. His response was one line. If he fires you on December 15th, we have a case. The termination, exactly as predicted. The termination came exactly when I expected. December 14th, 5:47 p.m. Victor called me into his office. HR director was there. I knew what was coming. Lauren, this is difficult. We've decided to make a change in the portfolio management team. Your position is being eliminated effective immediately. Immediately? As in today? Yes. We'll provide you with severance per your contract. Please collect your personal items. I looked at the HR director. What's the official termination date? She looked confused. December 14th. What time? The time right now? 5:47 p.m. So, to be clear, my employment ends at 5:47 p.m. on December 14th? Victor interrupted. Your employment ends today, Lauren. The specifics don't matter. Actually, they do. I want the official termination documentation to specify the exact date and time. The HR director typed something. I've noted the termination as effective December 14th at 5:47 p.m. Perfect. Exactly what I needed. I packed my things in silence. Victor watched, probably expecting me to argue or cry. I did neither. As I left, he said, Lauren, you're a talented professional. I'm sure you'll land on your feet. We'll see, Victor. I walked out carrying a box of personal items and a termination letter specifying December 14th at 5:47 p.m. I called Daniel from my car. He fired me December 14th, 5:47 p.m. Good. Good? I just lost my job one day before my bonus vests. No, you didn't. Your bonus vested. He just doesn't know it yet. Daniel, my anniversary is December 15th. Your anniversary is December 15th at 9 a.m., the exact time you were hired 10 years ago. They terminated you at 5:47 p.m. on December 14th. That means at 12:01 a.m. on December 15th, you were still employed. At 9 a.m. on December 15th, your actual 10-year anniversary moment, you were still technically employed because your termination was dated the previous day. That's splitting hairs. Employment contracts are about splitting hairs. The contract says compensation vests on your 10-year anniversary. It doesn't say end of day. It doesn't say calendar day. It says anniversary, which technically occurs at the moment you were hired. Will that hold up? Victor gave us the perfect setup by firing you the day before. If he'd fired you December 16th, we'd have no case. But December 14th termination means you were still employed when your anniversary moment occurred. We have grounds for arbitration. Arbitration? Your contract has a mandatory arbitration clause for compensation disputes. We file a claim arguing your compensation vested because your 10-year anniversary passed before termination became effective. How strong is the case? Depends on the arbitrator. But Lauren, titanium just saved a few hours of your employment to avoid paying $10 million. Courts don't look favorably on that kind of timing, especially when the termination date was clearly calculated to avoid vesting. File it. Daniel filed the arbitration demand 3 days later. We claimed breach of contract and demanded full vesting of my retention bonus and stock options. Titanium's response was aggressive. Their attorneys argued that employment ended December 14th, before the anniversary date, therefore no vesting occurred. Our response? Employment anniversaries occur at the hire moment, not calendar day. Lauren was hired December 15th at 9 a.m., therefore her anniversary occurred 9 a.m. December 15th. Termination effective December 14th at 5:47 p.m. means she remained employed through her anniversary moment. The arbitrator scheduled a hearing for February. Those 2 months were brutal. No income, job hunting while fighting a legal battle. James was supportive but stressed. We had 3 kids, a mortgage, and mounting legal bills. Lauren, what if we lose? Then we lose. But Daniel thinks we have a real case. The contract language is on our side. $10 million is life-changing. I know. The hearing lasted 2 full days. Titanium brought 3 attorneys. They argued that vesting based on hire time rather than calendar date was absurd interpretation and not the intent of the contract. Daniel's response was brilliant. The contract language is clear. It says compensation vests on the employee's 10-year anniversary. An anniversary occurs at a specific moment in time, the same moment as the original event. If Ms. Blackwell was hired at 9 a.m. on December 15th, her 10-year anniversary occurs at 9 a.m. on December 15th. The termination effective December 14th at 5:47 p.m. means she was still employed when that anniversary moment occurred. If Titanium wanted vesting to require employment through the full calendar day, they should have drafted the contract to say so. Titanium's attorney countered, "This interpretation would mean every employee's vesting time depends on what hour they started work. That's unworkable." It's exactly workable. Companies draft these contracts carefully. They choose the language intentionally. Titanium chose to terminate Ms. Blackwell precisely 1 day before her anniversary to avoid the vesting. They can't now argue that the anniversary date doesn't matter for timing purposes. The arbitrator asked pointed questions. Mr. Ashford, why was Ms. Blackwell terminated on December 14th specifically? Victor was under oath. It was when the decision was finalized. But you'd been documenting performance concerns for months. Why not terminate earlier? The timing wasn't related to her vesting schedule. Her vesting was December 15th. You terminated December 14th. That's not related? Coincidental timing. The arbitrator didn't look convinced. Michelle testified as my witness. She explained that Victor had a pattern of pushing out senior people right before vesting dates. She provided names, 3 other executives who'd been terminated weeks before major compensation events. Titanium's attorneys tried to discredit her. "You're Ms. Blackwell's friend, of course you support her." "I'm also a senior VP at Titanium. I'm risking my own job by testifying. I'm doing it because this practice is wrong." That testimony was devastating for Victor. The arbitrator took 2 weeks to issue her decision. Those were the longest 2 weeks of my life. When the decision came, Daniel called me immediately. "Lauren, you won. Everything." Everything. Full vesting, $2 million in retention bonus, stock options valued at current price, approximately $8 million, plus attorney's fees, plus interest from December 15th. Total award, about $10.3 million. I couldn't speak. I just sat there holding the phone. "Lauren, you there?" "They have to pay?" "Arbitration awards are binding and enforceable. They have 30 days. What was the reasoning? The arbitrator agreed with our interpretation. Anniversary occurs at hire moment, not end of calendar day. Since you were terminated December 14th but remained employed through your anniversary moment on December 15th at 9 a.m., your compensation vested. She also noted that the termination timing was suspiciously calculated and that Titanium's attempt to avoid paying by one-day timing demonstrated bad faith. Victor must be losing his mind. Victor is about to write you a check for $10 million. I imagine he's not happy. Titanium's attorneys tried to challenge the arbitration award in court. Their argument? The arbitrator exceeded her authority by awarding damages based on unreasonable interpretation. The judge dismissed the challenge. The arbitrator's interpretation of contract language is within her discretion. The timing of termination relative to vesting raises legitimate questions about good faith. The award stands. Titanium had 30 days to pay. On day 29, the wire transfer hit my account, $10,300,000. I stared at the account balance for a long time. James came home from work. Did it come through? It came through. He looked at the screen. Oh my God. Lauren, we're set. The kids' college, the mortgage, everything. Everything. That night, Michelle texted me, "I heard the payment went through. Congratulations. You deserve it." Thank you for testifying. That took courage. Victor's furious. He's been in his office all day. But Lauren, you did something important. You proved they can't just push people out before vesting and get away with it. She was right. Word spread fast in the private equity world. I got calls from 3 other executives who'd been pushed out before vesting. "Lauren, how did you win? Can your attorney help me?" I connected them all with Daniel. 2 of them had similar cases, terminations suspiciously timed right before compensation events. Titanium's reputation took a massive hit. Industry publications ran stories about the arbitration. One headline, "Private equity firm loses $10 million trying to avoid executive payout." The article quoted employment law experts. This case demonstrates why precise contract language matters. Companies that use technical timing to avoid compensation obligations risk significant legal exposure. Victor had tried to save $10 million. Instead, his decision to fire me one day early cost Titanium the full amount plus interest and legal fees, plus significant reputational damage. 3 months after the arbitration, I got a call from a competing firm. "Lauren, we've been following your case. We're impressed by your performance record at Titanium and by the way you handled the legal battle. We'd like to discuss a managing director position." The offer was substantial. $500,000 base, guaranteed bonus of $1 million, immediate equity stake, and a vesting schedule that started day 1, not year 10. I accepted. 2 years later, I'm managing director at Sterling Capital Partners, managing a $400 million portfolio with even better returns than before. The $10 million from the arbitration changed everything. We paid off the mortgage, fully funded college accounts for all 3 kids, invested the rest conservatively. We're set for life even if I never work again. But I love working. The difference now is that I work because I want to, not because I need to. That changes everything. I have leverage. I have freedom. I set boundaries. I work 60 hours a week instead of 80. I don't miss my kids' school events. I take real vacations. My new firm respects that because they know I don't need them. I choose to be there. James quit his stressful corporate job and started a consulting practice. With financial pressure gone, he can be selective about clients. Sophie's thriving. The twins are in a better school. Our family life is completely different. As for Victor, Titanium lost 2 more senior VPs within a year of my case. Both left before vesting, but with attorneys and better contracts. The firm's reputation for pushing people out before compensation events made recruiting difficult. Victor stepped down as managing partner last year. The board blamed him for the legal exposure and reputational damage. He's still with the firm, but in a reduced role. Michelle left Titanium 6 months ago. She's at a competitor now with a contract that protects her vesting schedule. Lauren, your case changed how all of us negotiate compensation. You proved we have power. I've become something of a legend in private equity circles, the executive who beat a firm trying to avoid vesting on a technicality. I get calls regularly from people asking about contract language and vesting protection. I always tell them the same thing. Read every word of your contract. Understand exactly when and how your compensation vests. Document everything. And if they try to push you out before vesting, fight back. Companies count on you being too intimidated or too broke to challenge them. Prove them wrong. Daniel Green and I still work together. He's reviewed every contract I've signed since. He's also built a practice around executive compensation disputes. My case put him on the map. Lauren, I have 3 clients right now fighting similar situations. Your arbitration award created precedent. Companies can't use one-day timing tricks anymore without massive legal risk. The best moment came last month. I ran into Victor at an industry conference. He saw me, started to turn away, then stopped. Lauren. Victor. Awkward silence. You look well, he finally said. I am well, managing a $400 million portfolio, excellent returns, and actually seeing my family. It's been good. I heard you landed at Sterling. I did. They offered me a much better compensation package than Titanium ever did. Immediate vesting, equity stake, guaranteed bonuses. Turns out when you treat executives well, they perform better. He flinched. Lauren, what happened was business, nothing personal. You tried to steal $10 million from me by firing me one day before it vested. That's pretty personal, Victor. The timing was coincidental. The arbitrator didn't think so. Neither do the 3 other executives who filed similar claims against Titanium. Neither does your board, apparently, since they demoted you. I'm still managing partner. You were managing partner. Past tense. Enjoy the conference, Victor. I walked away feeling lighter than I had in years. People ask if I'm bitter about what Victor tried to do. If I hate him for almost stealing 10 years of my career compensation. I'm not bitter. I'm grateful. Grateful he was dumb enough to fire me one day early instead of waiting. Grateful he didn't read the fine print. Grateful he underestimated me. If Victor had fired me on December 16th, one day after my anniversary, I'd have no case. I'd have lost everything. He'd have saved $10 million. But he got greedy. He thought he could squeeze the timing and save the money. He thought I wouldn't fight back. He thought the contract language would protect him. He was wrong on every count. Here's what I learned. Contract language matters. Every word, every clause, every timestamp. Companies write these contracts to protect themselves, but those protections go both ways. Victor used my contract to try to screw me. That same contract saved me because he didn't read it carefully enough. I also learned that fighting back is possible. It's expensive, stressful, and scary, but possible. Most executives don't challenge these situations because they can't afford the legal fight or they're afraid of reputational damage. I could afford it, barely, and I decided reputation was less important than $10 million. I was right. The arbitration award didn't just give me financial security. It gave me power, leverage, freedom, the ability to work on my terms instead of someone else's. Victor tried to time my termination to steal compensation I'd earned over 10 years. Instead, his timing error cost Titanium millions and destroyed his reputation. The contract said my compensation vests on my 10-year anniversary. He fired me the day before the calendar date, but my anniversary occurred at 9 a.m. when I was hired, and I was still employed at that moment. One day, 15 hours, that's what he lost on. Sometimes success isn't about being the smartest person in the room. It's about reading the contract more carefully than the other guy. Victor learned that lesson the expensive way. I learned to stand that standing up for yourself is worth it, even when, especially when, they try to take everything at the last moment. My 10-year retention bonus was supposed to reward loyalty. Instead, it rewarded reading the fine print and having the courage to fight when someone tried to cheat me. Best $10 million I ever earned.